Are you tired of work invading your personal time? In this video, we're breaking down Australia's new Right to Disconnect law and what it means for you. From the 26th of August 2024 for larger employers and the 26th of August 2025 for small businesses, employees in Australia now have the right to refuse to monitor, read or respond to work-related contact outside of their regular working hours unless it's unreasonable to refuse. The goal is simple: to help employees maintain a healthy work-life balance and prevent burnout. Constant connectivity blurs the lines between work and personal life, and this law aims to set clearer boundaries. It's important to understand that this doesn't mean your employer can't contact you. It means that you have the right not to respond when you're off the clock, if it's reasonable to do so. For example, if you're a casual worker on call or a surgeon with emergency duties, there might be a legitimate reason for the contact. But in most cases, routine tasks like responding to emails or calls outside of hours should wait. Every company and industry needs to set clear guidelines for when out-of-hours contact is acceptable. These expectations should define specific criteria for what is truly business critical and ensure that employees at any level can disconnect at the end of the day without fear of penalty or reprisal. Businesses must clearly define situations where out-of-hours contact is justified, like emergencies or legal obligations. Managers need to ensure that these expectations are specific, and this standard clause may be required to work outside of normal work hours isn't a blanket excuse for unnecessary after-hours contact. Certain roles like senior management, executives or those working globally may need to be available outside of normal hours. But even then, the right to disconnect still applies and local laws must be respected. Managers need to be crystal clear on what is considered critical and the responsibilities of each employee, rather than relying on personal preference or poor planning to justify after-hours contact. Employers should update contracts, policies and processes to align with the new law. Employees should know that they have the right to disconnect. But as always, if you're unsure how this affects you, seek advice from the Fair Work Commission, a lawyer, or your HR department.